Family law is a lot of different things, right? We family law attorneys deal with divorce and separation, of course, and with custody and visitation, but we also get to do what I refer to as the happy side of family law, which is adoptions. A lot of times when we in our office are dealing with adoptions, it is because there is somebody who loves that child and is saying, yes, you're mine. I want to make this formal. I want to adopt you. And they come to us to help finalize that process and formalize that process. So that's what we're going to be talking about in today's video. I'm Darlie Twitty, and I am one of the litigation attorneys in our Newport News office here with Melone Hatley. So there are a number of different types of adoption, and two big distinctions are we talking about agency adoption or parental placement adoption? And today's video is going to focus more on parental placement. So a lot of times I have clients, unfortunately, where one parent is super involved and is raising that child or those children, and the other parent is not so involved. And they say, well, can't he just sign his rights away? He says he doesn't want to have anything to do with them. He just wants to sign his rights away. And the easy answer is probably not, because as the courts see it, a child has two parents, and the court doesn't want to come in and say, no, you only get one parent. And so there's ways to prevent pregnancy before it happens. Once the children are here, you not only get the joys of having those children in your lives and get to have visitation and spend time with your children, but you also have an obligation and a responsibility financially. So if there's a parent who's not involved, they can't just sign their rights away. The other parent who is more involved would be going to court and fighting for custody, and would be potentially asking the court to determine visitation. And that might mean no visitation to the other parent. The other parent might say, you're right, I don't want to have anything to do with this child. But even if that's the case, the court is probably going to order that other parent pay child support. That's still going to depend on both parents' incomes and all of that. But that parent won't have had their parental rights terminated. Both parents are still the legal parents of that child, which means that they have rights to custody and visitation, and they have rights to potentially later inheriting from that child. You know, if your child is some child star or something like that, that doesn't come up as much, but they also have that responsibility to financially support the child. So in most circumstances, no, a person can't just come in and sign their rights away to the child. This is not legal advice. Go talk to an attorney. Every situation is different, but in most circumstances, that's not the case. So that would most likely be a custody and visitation issue. Termination of parental rights is usually when there's abuse or neglect, or a parent is incarcerated, Department of Social Services is getting involved. That is more of that agency placement when you're not dealing necessarily with a newborn. And there are all kinds of review processes and hearings and steps that would have to be gone through for that to happen. What I see more often is a very involved biological parent come in with a step-parent who has been what the courts and what the Commonwealth uses, the old Latin phrase, in loco parentis. So that step-parent has been involved in that child's life for quite some time, has been raising that child as their own, and is standing in as the parent where the biological parent is not. So if you've got an absent father or an absent mother, and then you've got a biological parent who is married to another person, so they've got a step parent, that step parent can adopt that child under certain circumstances. And I see that a lot. What that would involve is the step parent would be my client. They want to petition the court to adopt that child. So I have to ask a few things. And so these are things, if you're potentially considering step-parent adoption, that you're going to want to track down or make sure you have this information available when you come to talk to one of us, is, do we know who dad is? This is more often, of course, with fathers than mothers, because we usually know who mom is. But do we know who dad is? Was he married to mom, so he's a presumed father at the time of the child's birth? Or was he potentially a putative father? So mom didn't put him on the birth certificate, but he knew the child was born, and he went and put himself on the Virginia Putative Father Registry so that he could stake a claim to that child. If things were kind of going on behind his back and he wasn't informed, there's a way to do that. Or was he an acknowledged father because the mom said, yes, you're the father, and I'm acknowledging that? Or was he potentially an adjudicated father where they went to court, the parents went to court and probably did some genetic testing and found out, yes, you are the father without Maury Povich involved. The court said, yes, you're the dad. So if you are the father because of any of those ways, we know you're the dad. And you're not the person that's going to be stepping in as, you're not the biological parent that's raising the child. You are the absent father. Then the question is, does biomom consent to stepdad adoption? Biomom's married to stepdad. She consents. That's step number one. Great. Now, does biodad consent? If he does, things go a lot more smoothly because you've got both biological parents consenting to this adoption. From the court's perspective, that child is going from 2 legal parents to 2 legal parents. If biodad, who is an absent father, does not consent to the adoption, then the question is, well, is he doing so contrary to the best interest of the child? And a lot of you might have heard or seen videos or talked to your attorney about the best interest of the child factors when it comes to custody and visitation. The court does consider those, but these best interest of the child factors are actually slightly different when we're talking about consent to adoption. So make sure that you're looking at the right statute when you're looking at best interest of the child factors related specifically to step-parent adoption and consent of a biological parent. If the absent parent is not consenting, they're refusing to consent, maybe because you can't find them or get a hold of them, or maybe because they're just trying to be difficult. Whatever the case may be, if they are refusing consent and you can show that that is against the best interest of the child, then the court can still order step-parent adoption. Now, there are some circumstances where the court might say, I don't need the biological parent's consent. The number one reason is the other biological parent is deceased. Of course, if they're deceased, they can't consent, but the other remaining parent can come to the court and say, I consent to this. I've been married to this person for however long. The child has lived in their home with the step parent for a certain amount of time. And so check on those things. Different rules and procedures will vary based on how long the child has lived with that parent. If it's a close relative and the child's lived in the home for up to 2 years or over 2 years, things are a little bit different. With a step parent, it changes at about the 5-year mark, at least in Virginia. So those are some things you're going to want to consider. But if the biological parent that is not the parent consenting to the adoption is deceased, that's one way you wouldn't need their consent. Another way is if the child who is being adopted is 14 and they've lived in the home with that step parent for at least 5 years and the child consents, then that's okay. So a lot of times when I'm talking to parents who want to adopt as a step parent, I'm asking how old is the child? Because if they're 14, then that's an avenue that we can use instead of getting the biological parent's consent. Another way or other considerations, there are a list of them, but if the parent who I keep referring to as the absent parent or the absent father, when I say absent, I mean that person hasn't had contact with the child for at least 6 months before you file. So if this parent is going half the year without reaching out to the child and without having contact to the child, then they're essentially abandoning the child. So you can't then come in and be like, oh no, I don't, I object to this adoption, but I haven't been around. Like I said, the court wants this child to have 2 parents. And if the child has one parent that's not around, then you can't then come in and say, oh, now I want to be around. I mean, it depends on the circumstances. It depends on the, what's going on in your particular situation. But generally, you don't want to be absent for 6 months. Dads, unfortunately, this is more often the case for you. If you are an absent father and you don't want your child to be adopted by their step parent, you need to be involved. You need to be reaching out to those kids. You need to have a relationship with them. And if you can't communicate with mom, then you need to come talk to an attorney so that you don't have your child adopted out from under you. There are a number of things that the courts consider. There are a number of steps. There are a number of questions your attorney is going to want to ask you if you're considering step-parent adoption. There are also a few other types of adoption, like I've seen grandparents adopt their grandchildren with the consent of their children, the child's parents. I've also seen it against the child or parents objection. So close relatives can adopt. That's not just grandparents. Other people with a legitimate interest, which is a statutory term with a very specific definition. Step-parents is what I see most often. And like I said, it's what I refer to as the happy side of family law. I'm always excited to get an adoption case. We are here to hold your hand and to partner with you through your divorce, through your custody and visitation matter, through whatever family law matter you have. But I will admit, I do get excited when I have an adoption case walk through my door because it is a happy moment. We're taking pictures at the courthouse and you get to get a new birth certificate and go live your life as a family like you have been, but it is official. So if you are considering adoption or you have some more questions about it, whether you are the biological parent who is going to stay in the child's life, or whether you're that step parent or other close family member, or even whether you are the parent who hasn't been around or maybe considered an absent parent or has been asked, will you consent to this adoption? Come talk to an adoption attorney, which we at Melone Hatley, we are family law attorneys, and adoption is part of that, the happy part of that. So come talk to one of our attorneys here at Melone Hatley. We'll set you up with the consultation and we will get you on your way to your happy family.